I think we're ready to get started. Morning, everyone. You hopefully can see both of us. We can't see you. I can tell you that when I first volunteered in May 2020 to do one of these seminars, I did the entire thing with my camera off and couldn't work out how to get it on. So I'm hoping this one goes a little bit better. We are going to be speaking for about an hour or just under. I'm starting with covert recordings, and Emma is going to continue with H&N, talking about domestic abuse, coercive control, and where that case takes us. If you have any questions or answers, feel free to pop them in the Q&A box. And if we have got time, we'll certainly have a bit of a chat at the end and deal with any questions that arise. I'm going to start then with screen sharing. It's stressing me out more than putting a man on the moon, so let's hope it goes okay. I hope that you can see my title page, maybe if Emma nods. Oh, she's nodding, there we go. So I have given this the title, here's one I made earlier, because it struck me that clients, parents can often come to their solicitors or counsel with a very much pre-prepared batch of evidence presented on a plate, which absolutely proves their point, but everyone's heart sinks a little bit when they hear that it's covert recordings because of the myriad issues that that can raise. I'm going to deal today with 3 types of covert recording because they are all distinctive and they all throw up their own issues. The first type of recording I'm going to deal with is recording professionals. I know that's something that concerns social workers, CAFCAS officers, and other people involved in the family justice system. Secondly, I'm going to look at parents recording each other, and also then the recording of children. I thought we could start with Medway Council and A. It is a decision of Her Honour Judge Lazarus. These were covert recordings of a foster carer. It was all a little bit last minute because this set of recordings wasn't provided until a week before the hearing. So I'm sure advisors were wondering if that was going to prove fatal or not. It wasn't fatal. The parents in that case had made quite serious allegations against a foster carer, that the foster carer had been abusive, racially insensitive. And in the judge's own words, those allegations had been treated actually quite dismissively from the outset. And without those recordings, the parents' allegations probably weren't going to be found. But the court did rely on the allegation, or forgive me, the recordings. And Her Honour Judge Lazarus said, but for this court's willingness to permit the consideration and transcription of recordings, despite the extreme lateness that they were provided, in combination with the requirement that the foster carer attend to give evidence, it would have been impossible to gain a just and proper understanding of this case. So I think that case really places recordings at the center of the court's decision making and just demonstrates how important they can be. It sounds like in this case it was really make or break, because the initial reaction to what parents were saying wasn't really treated very seriously at all, and this turned their case around for them. When we're looking at recordings of professionals, I came across the Transparency Project paper from December 2015. The Transparency Project asks just a really simple question: why do people record? think there can often be a knee-jerk reaction that perhaps there's a sinister reason behind it. Perhaps the parents might be on the campaign trail, or might be motivated by a desire to distribute the information, perhaps online. But some other simple reasons were provided as to why people might want to record. Really straightforward. Someone might have a disability. They might have an auditory processing disorder, a difficulty with working memory, something that makes it easier for them to have a recording to go away and listen to again and process properly. So disability certainly seems to be a good reason to record something, and a reason that people should have some sympathy with. The other reason is perhaps connected. It's the large amount of information that can be disseminated in meetings, lots of discussion, lengthy meetings. It's a lot for someone to take in on the hoof, so to speak. So they might want to be able to have that information and go back to it and think about what was said. There's another obvious reason, which is lack of trust, which the Transparency Project has highlighted again and again. Then there's the unreliability of the minutes. And finally, the most troubling one, which would be the desire to disseminate information inappropriately. The Transparency Project highlighted that it's not actually the making of the recording that's problematic, it's the distribution of it. And those who record meetings, whether it's on an overt or a covert basis, if they disseminate that information, if the recording involves family proceedings, then they could well find themselves in contempt of court and facing very serious consequences. Meetings, of course, can't be recorded in order to intimidate or harass a professional. An example is the recording device being thrust at someone. That's inappropriate. But the Transparency Project suggested that if a parent wishes to record, then why not be open? Why not say so in advance? It helps everybody feel comfortable, provide a bit of reassurance that there's no intention to do anything inappropriate, but have that open discussion. Think also, if meetings are being recorded, about the quality of the recording. That's perhaps more of a difficulty with covert recording. If something's shoved in someone's pocket, or there's a device that isn't working properly, it may be very, very difficult to hear. You may have to think about transcribing the recording, and that comes at a cost. I've also referred you to Re-F, which is another care case, and those were recordings made of a psychologist. The mother made, again, very serious allegations against court-appointed expert of false reporting and inaccurate quoting. In this case, the court did admit the covert recordings, and that certainly turned the mother's case around in terms of what she was saying about the expert evidence. One example the court gave after listening to the recordings and comparing to the report is there were extensive parts of the report that had quotation marks as if they were direct speech, something the mother had said, but the judge said they're nothing of the kind. They were recollections and impressions compressed into phrases created by that psychologist and attributed to the mother. The court goes on to use the recordings in a different way. The court looked at the length of the meeting or the assessment, looked at what the psychologist had said had been covered, and wondered how 13 topics, some of them really complex, serious topics, have been covered in such a short amount of time. So again, undermining what's said in the report, by the use of recordings. The court was unfortunately very critical of that expert and found that that was someone who had overreached his material. And it involved, as you'll see there, a manipulation of the material, which is wholly unacceptable. Those are the two examples I wanted to give you of recording professionals. Moving on now to Re C, which is a Court of Appeal case. Father was recording child, he was recording handovers, discussions with mother, plethora of different kinds of recordings. They went through a set of proceedings, which ended up with the father agreeing not to record any further. But lo and behold, he obviously wasn't able to contain himself or refrain from recording, so he began recording again. The mother applied for a non-molestation order. The judge listened to these recordings. I think one of them was about the fact he said he'd perhaps been banging on the door when collecting the child from handover, and mother wasn't coming to the door or something like that. When the judge listened to the recording, the judge found that it didn't match what the father said had happened. So a note of caution to be really careful that the recording actually shows what you are saying. It shows. Well worth listening to the recordings and not simply relying on what a client says it contains. But what the court did confirm was recording can be a form of abuse. It's of course fact specific. Cannot say that simply because it was covert, it wasn't capable of causing harm. I think the argument there was, well, if you don't know about it, what harm does it do? You didn't know you were being recorded. That's not good enough. And injunctions can be sought to prohibit not only covert recording, but also overt recording as well. And this is the relevant paragraph that I've given you from the judgment, which might help if you're in a similar situation, that you, in the right circumstances, are able to argue that it amounts to abuse and seek the appropriate protection for a client. You might be familiar with M and F. It comes up again and again in respective covert recordings, and that is Jackson J, who says, in no uncertain terms, it's almost always likely to be wrong for a recording device to be placed on a child for the purpose of gathering evidence in family proceedings, whether or not the child is aware of its presence. This is a case where there were really, really extensive recordings. They had been made for over a year. All but one included the child. As I read it, bugs, devices were being sewn into the clothing, variety of different mechanisms were used. And then I think it was father's partner, stepmother, who would transcribe some of these. So it does sound like a bit of an operation. The child wasn't aware she was bugged, but that didn't get around the criticism of father in that case. The court was satisfied that they ought to be admitted, but unfortunately for father, the court said the manner in which they were made is directly relevant to an assessment of the parenting offered by the father and his partner. So I think that's a risk that we are all aware of, that the court might say, this recording says more about the recorder than the content or the point that's being made. The court also makes an interesting point in it's theoretically possible for the court to receive evidence that recordings have been made. That can be said, but not their content. But in that case, it would risk unbalancing the evidence. So effectively, if the contents were of any value, then that ought to be heard. M&F is a real health warning for covert recordings. The court said the recordings were selective. They weren't professionally transcribed. I think that was the least of the father's worries, because the court went on to say, actually, what it did was damage the relationships between adults in Tara's life. It showed his inability to trust professionals. But importantly, despite the fact that Tara knew nothing of the recordings, what the guardian argued and what the court accepted was that the child's at risk of harm arising from the recordings, because what happens if it comes to her attention that her father has been bugging her? The guardian said it would be extremely damaging for Tara if that came out in future in some uncontrolled way. And that's something that would likely to cause her confusion, distress, and seriously affect her ability to trust people. The court says anyone who's considering doing something similar should therefore first think carefully about the consequences. I think in that case, the father ended up paying some of the mother's costs in respect of the recordings as well, which ran to several £1,000s. The judge made it clear that that judgment wasn't about recording adults or professionals, and pointed the parties in the direction of the CAFCAS operating framework, which says that when it comes to recording those officers, they should have nothing to fear. The judge didn't encourage it, though. We then come on to Re B, which was originally a case which came before His Honour Judge Bellamy. The father had made allegations of alienation. He had been making recordings again for years. A variety of conversations with professionals were covered. But what His Honour Judge Bellamy did in an effort to assist was try to generate some discussion about covert recordings where he saw there was a lack of real guidance for practitioners. So he invited submissions from a variety of organisations, as you can see. Unfortunately, His Honour Judge Bellamy was criticised by the appeal court for taking it upon himself to issue guidance, however well-meaning. But one thing the court did observe was the examples of professional malpractice over the years, which have only been established through covert recording. And they refer back to the two cases that we've already looked at with the foster carer and also the psychologist. The court identified the number of issues that covert recordings throw up, and they said, and they cited His Honour Judge Bellamy with some approval on this, applying for permission, the court's power to control the evidence, and the court's power to exclude evidence that would otherwise be admissible. Those are the cases that I wanted to draw to your attention. I think they cover the variety of different types of recordings that can be made and the issues that arise. You can see that in all of those cases, the court accepted the recordings, and in each of those cases, they demonstrated just how the admission of those recordings took that case, those cases, in very different directions of travel, revealing unprofessionalism, bad practice, but also recording that's tantamount to abuse and is capable of being prohibited by use of an injunction. Emma very helpfully pointed me in the direction of the debate held in 2018 by the Family Justice Council. Nothing to hide, what's wrong with covert recordings? And I wanted just to highlight some of what was said during that debate. I think the fact that it's a debate just proves the point. There is no hard and fast rule and no right answer to covert recordings. Each case turns on its own facts, and it really is open to argument how each court will deal with each set of recordings. But some of what was said, I've highlighted. For example, Her Honour Judge Lazarus, who was the judge in the case with the foster carer. She identifies the culture of distrust motivating those who wish to record. She also asks, why don't we record meetings? Why don't we store them? We do it with police and body cams and ABE interviews. So she says, let's get rid of covert and make it overt. Let's have trust, accuracy, and let's have a recording so that there can be no argument over what was or wasn't said. Hannah Markham QC also added to the debate, and she talked about the fact that people often ask, are they illegal? She didn't think it was much of an issue in most cases because they are private recordings. They probably haven't broken the law. And she made an interesting point, which was judges don't mind being recorded. They're happy to have their words brought back to life by transcripts. We've got transcripts in all of our hearings. Why aren't we doing it in professional settings? I thought that Hannah Markham made a really interesting point, because I think all too often people might come with a huge number of recordings, perhaps lasting hours and hours, if not longer. So what do you do? If you are wanting to rely on those, you're going to be concerned that it's going to affect the listing time. Perhaps something will have to be relisted. Is it in accordance with the overriding objective to ask a court to sit and listen? She had quite a nifty idea. She said, you pick your best 30 minutes of the recording, we'll pick our best 30 minutes of the recording, and see what the judge makes of it. That might be a way of distilling it down and making it more manageable for the court. She also asked a question that probably everyone should be asking themselves if they want to rely on recordings. Can I explain why I said what I said or why I did what I did without needing to listen to that covert recording? Why is it necessary? Debbie Singleton from NIAS was also involved in the debate, and she identified the problem with some private law cases where recording is about control, and she was worried about that. She also talked about a case that she'd been involved in where there was a dispute between parents in private law. One of the parents had been recording. This was an incident where the child had been present, turned into an argument. The father demonstrated the mother's appalling behavior and her hatred of the father. That was, as far as he saw it, his job done. But what she said there was he didn't come off scot-free either, because instead of ending the call and saving the child from witnessing that dispute, he allowed it to continue, because his desire to gather evidence was greater than his desire to protect his own child. So he came in for criticism as well. She goes on to say, without question, both parents had lost focus on the child. So I think that's a word of warning if you are tempted to just allow a set of circumstances to unfold to which your child is witness in the name of improving your case. She said that she would be asking a lot of questions before recordings or references went into cases or have input into Guardian's reports. She's got another quotation there that might be of some help. I just finish off with some tips. Ask why the court needs to see or hear the recording. What is its relevance? and be prepared to explain why the recording was made, the date of the recording, the way in which the recording was made, and its context, as well as disclosing the entire recording. So if there is someone who has not covered themselves in glory 10 minutes in, but only wants to disclose the first 5 minutes, they may find themselves in real difficulty because it's an all or nothing type approach. I think it's similar to possibly what we're finding with text messages or WhatsApps, which is guarding against cherry picking. So those would be my tips in respective covert recording. It was a bit of a whistle-stop tour of what is quite a big subject, and really creates all kinds of debates between practitioners, professionals, and parents. When my slides are circulated, there'll be the links to the cases. There'll also be the link to the Transparency Project document that I referred to as well. I hope that some of the extracts from some of those judgments might help you and save you some time, just in terms of honing in on the key parts and what was said if you find yourself in a dispute about whether or not recordings ought to be relied on. I'm going to hand over to Emma now. I think I'm just about bang on time, I'm not sure, but I hope that was helpful. And I'm going to stop screen sharing.
Thank you very much, Aimee. I'm going to talk about the recent case of Re HN, a decision of the Court of Appeal, and what guidance it gives us as practitioners when dealing with cases that involve domestic abuse generally, and in particular, the rather vexed issue of coercive control. And I'm afraid I'm sorry, I'm just having problems with my screen. I hope now you can see my first slide. There I set out the reference to Re H and N and the focus of my talk this morning. I'm sure that most of you will be aware that Re HN was a much awaited decision of the Court of Appeal in its determination of 4 individual cases, each of which involved allegations of domestic abuse by one parent against the other in applications under the Children Act 1989. Its significance, however, is not in respect of those individual appeals, but rather in relation to the guidance that the Court of Appeal gave generally in respect of domestic abuse, and as I said, in particular in relation to coercive control. I'd just like to start with a bit of context, as does the precedent at the beginning of Re HN. I'm sure we are all acutely aware of the huge volume of cases that we as family practitioners deal with day in and day out that involve issues of domestic abuse. And you'll see from the figures that I've set out on that slide that it can be up to 22,000 cases a year that the family court have to deal with and grapple with issues of domestic abuse. And the fact of the matter is that there is no evidence, certainly at the moment, that those numbers will decline. In fact, following the global pandemic, it appears that, in fact, the court is going to be faced with an increasing number of cases involving domestic abuse. And I've set out there a section from the Office of National Statistics, crime figures. And while they suggest that there hasn't necessarily been an increase in victims, what they do say is that there's been an increase in victims seeking support services which would suggest that the severity of abuse that is being perpetrated has escalated. And it would seem to me that that inevitably is going to have a knock-on effect on the work that we do when dealing with applications in the family court. I'd like to start with some definitions. I'm sure we all have an idea of what coercive and controlling behaviour is, but I cannot recommend highly enough going back to basics and going back to Practice Direction 12J and looking at the assistance that it gives us in determining whether or not we have in fact got a case where there is evidence of coercive and controlling behaviour. What ReHN does is confirms that Practice Direction 12J as currently drafted is indeed fit for purpose. The issue and the difficulties that victims and or those representing victims and indeed perpetrators or alleged perpetrators in the family court face is not due to Practice Direction 12J itself, but due to its inconsistent implementation. We're all familiar with the general definition of domestic abuse, and that includes any incident or pattern of incidents of controlling, coercive, or threatening behaviour, violence, or abuse between those aged 16 or over who are or have been intimate partners or family members, regardless of gender or sexuality. This can encompass, but is not limited to, psychological, physical, sexual, financial, or emotional abuse. Practice Direction 12J goes on to further define coercive behaviour, which means an act or a pattern of acts of assault, threats, humiliation, and intimidation, or other abuse that is used to harm, punish, or frighten the victim. And there is a distinction, and in my submission, it is important to bear this in mind when considering the issue of coercive and controlling behaviour, is that they are inherently different. So controlling behaviour means an act or pattern of acts designed to make a person subordinate and or dependent by isolating them from sources of support, exploiting their resources and capabilities, capacities for personal gain, depriving them of the means needed for independence, resistance, and escape, and regulating their everyday behaviour. Now, of course, they overlap. Coercive behaviour can be controlling behaviour and vice versa, but you don't need to prove one to have the other. And so it is very helpful to have those distinctions, and you will see from those distinctions is that the real essence, the difference in their characteristics is the impact that it has on the alleged victim. And that's why the definition of harm is also important. And that means ill treatment or the impairment of health or development, including, for example, impairment suffered from seeing or hearing the ill treatment of another by domestic abuse or otherwise. Now, the concept of coercive control, in fact, has been around for some time and was incorporated into the Practice Direction 12J in 2014. And it's derived, and the terminology was popularised by Evan Stark in his book in 2007. And you'll see there that I set out his assertion that is coercive control, in fact, is the most pernicious form of domestic abuse, and indeed is the most dangerous. And that is something that is an analysis that has been endorsed, certainly by the criminal jurisdiction, because that citation was used in the guidance that was issued when Section 76 of the Serious Crime Act was brought into force, making it a criminal offence to coercively control an intimate partner. And we can see in ReHN that the President in that case emphasised and reiterated the pernicious and harmful impact of coercive and controlling behaviour. The court emphasised that it can cause serious emotional and psychological harm, whether or not there's been any actual episode of violence or abuse, and in fact can be abusive as, or even more abusive than one particular factual incident of violence, for example. And I'm sure we've all been faced with judges and or magistrates who say, well, Ms. Griffiths, this is at the lower end of the scale. Well, where's the actual violence? This case, the case of Re-H&N, puts at the epicenter of any case involving domestic abuse the issue of control and coercive control. To assist those who are faced with persuading a court that coercive and controlling behaviour is relevant to a Children Act application, the President summarises or gives examples of the harm that can arise to a child if they live within a household where there is coercive and controlling behaviour. They can be affected if that behaviour is directed to them or witnessed by them. If it is such that the victim is so frightened of provoking an outburst that they are unable to give priority to the child, and that's something that those of us who practice care will be all too aware of. But also, if it creates an atmosphere of fear and anxiety, the concept of walking on eggshells, that in of itself is harmful to a child or any child. And interestingly, and I was very pleased to see this, I have to say, there was an emphasis on inculcating, particularly in boys, a set of values which involve treating women as being inferior to men. And that, in my submission, goes to the very heart of domestic abuse generally, whether it's men against women or women against men. And it's very important that this case recognises that the majority of instances of domestic abuse, sadly, are perpetrated by men against women, and it's endemic within society. In Re-H&N, the court endorsed the only other, in my research, significant case dealing with the issue of coercive and control, and that's the case of F&M. This was a decision by Mr. Justice Hayden. If you do have the opportunity to read it, I would highly recommend you do. It's quite disturbing, and there is no doubt that the behaviour set out in that case is, as pointed out in Re-H&N, at the higher end of the spectrum. But the character of the incidents that are described relate to all and are indicative of coercive and controlling behaviour generally. And what Mr. Justice Hayden emphasises is that the term coercive and controlling behaviour is fairly unambiguous and needs no embellishment. But what's important, as I've already mentioned, is that when considering whether you do in fact have a pattern of coercive and controlling behaviour, it is important to look at the intention of the perpetrator and the reaction that those steps taken provoke in the alleged victim. He makes the distinction between coercive control, coercive behaviour, and then controlling behaviour, and also makes the point that what is key is that there is a pattern or a series of acts, and that those must not be taken in isolation, but they should be looked at cumulatively. As I said, in Re-H&N, the President endorses the decision of Mr. Justice Hayden, endorsing the fact that in that case, the incidents, although, as I said, were towards the higher end of the spectrum, their essential character is not. And as I said, I would highly recommend anyone to read that case. It also sets out and makes references to the statutory guidance that followed the offence of coercive control. And as the President says, it highlights the paradigm behaviours of controlling and coercive control. And in this next slide, I don't intend to go through it, but I thought it would be a useful reference point, set out examples, and it's not an exhaustive list, of coercive and controlling behaviours. Another very useful resource that I found is actually in the CPS guidance for gathering evidence in respect of coercive and controlling behaviours, because in my view, these can be exquisitely difficult to prove if you don't have overt violence. As we know, domestic abuse very often involves one person's word against another. So this again, and I've included a hyperlink. When you get the slides, you'll be able to be taken straight to it. But again, I think this gives a very helpful guide to the types of evidence that may be useful in proving a case of coercive control. Another important point that arises out of Re-H&N is making the distinction between abuse and bad behaviour. And that, as we all know, can be hugely subjective and is not an easy question to decide. What the President says, it is equally important to be clear that not all directive, assertive, stubborn or selfish behaviour will be abuse. And again, as I said, when looking at the definitions, it's really important to look at the intention of the perpetrator and the harmful impact of that behaviour on the alleged victim. So it's not enough simply to say, well, here's a pattern of behaviour. The important questions to ask your clients is, how does that make you feel? Did that stop you doing something that you really wanted to do? Those sort of questions that I'm sure you're very used to asking day in and day out. And in Re-H&N, they very usefully set out a passage from a decision of Mr. Lord Justice Jackson. And it is a very useful passage in my view. What he said then was, few relationships lack instances of bad behaviour on the part of one or both parties at some time, and it is a rare family case that does not contain complaints by one party against the other, and often complaints are made by both. Yet not all such behaviour will amount to domestic abuse, where coercive behaviour is defined as behaviour that is used to harm, punish or frighten the victim, and controlling behaviour as behaviour designed to make a person subordinate. In cases where the alleged behaviour does not have this character, it is likely to be unnecessary and disproportionate for detailed findings of fact to be made about the complaints. Indeed, in such cases, it will not be in the interests of the child or of justice for the court to allow itself to become another battleground for adult conflict. What the court in Re-H&N identified was essentially 4 issues that they felt able to address in terms of offering pointers of general guidance. Firstly, whether or not there should be a finding of fact hearing, the challenges of Scott schedules, if a fact-finding hearing is necessary and proportionate, how should allegations of domestic abuse be approached, and lastly, the relevance of criminal law concepts. And you may all be familiar with the rather scathing judgment of Mrs. Justice Russell in respect of a decision by His Honour Judge Tolson, where he was criticised for his lack of knowledge of concepts such as rape. And it's quite clear from the judgment of Re H&N that the court had in mind the vociferous criticisms of Mrs. Justice Russell in that case. Firstly, should there be a fact find? I've set out here the summary that the Court of Appeal gives. It's back to basics. It's back to practice direction 12J. There is nothing new. The first stage and the most important point is, if these allegations were to be proved, would they be relevant in deciding whether or not to make a child arrangements order, and if so, in what terms? And the court emphasises that in directing that there should be a fact find, the court must have at the forefront of its mind the purpose of that fact find in relation to the arrangements of the child. Is it needed to undertake an assessment of risk in relation to an alleged perpetrator? So that is very important. Again, is it necessary and proportionate? Again, emphasising the need for the factual allegations that are made. Are they relevant? The court also makes the general point about the need to have an eye on the overriding objective and the President's guidance in as set out in the road ahead. And what I'm going to go on to discuss is how, in fact, the court grapples with the vexed issue of determining allegations of coercive control without exponentially increasing the length of hearings. But before I do that, the second issue that arises is that of Scott schedules. I'm just going to have a quick note of time. I think we're okay for the moment. As far as Scott schedules are concerned, the Court of Appeal made it very clear that we need to move away from Scott schedules. And in fact, rather than assisting the court to come to a fair determination when there are allegations of domestic abuse, they are a potential barrier to fairness. The two bases upon which they say, well, the two bases for the concerns are the principal basis. Of course, coercive and controlling behaviour is a pattern, and the court needs to focus on the wider context of the relationship between the two parents, rather than concentrating on specific factual incidents that are tied to a particular date and time. And the second basis for concern is related, but it's more a pragmatic question, is that we all have been faced with judges saying, yes, you can put in your schedule, but you are limited to 6 allegations. And then you get to court and the judge puts effectively a red line through several, if not all of them. And again, what the Court of Appeal said is that in limiting allegations, the court is robbing itself of the vantage point from which to view the quality of the alleged perpetrator's behaviour as a whole, and it removes the ability to consider whether or not there was a pattern of coercive and controlling behaviour. So, what I'm sure you're all on tenterhooks for is, what should we do instead? What's the alternative to a Scott schedule? The answer is, we don't know. Although the Court of Appeal said, yes, we must move away from them, it was very clear that it's not its role to do more than simply set out what the options are. And it's going to be a matter for other bodies, such as the Private Law Working Group, working together with the harm panel, and it may indeed in time result in an amendment to the family proceeding rules, or indeed a completely separate practice direction. But this court was not prepared to do anything other than provide us with suggestions. There were 3 suggestions. The first was a threshold type document. For anyone who does care proceedings, they will know exactly what that is. Formal pleadings by way of particulars of claim in civil proceedings, and or a narrative statement in a prescribed form. As I've just said, that any changes will come not from the court, but through a practice direction or change to the rules. If I was to be asked what would be my preferred method, I do see the merit in a schedule akin to a threshold document, because it seems to me that it would be extremely helpful for the court to have parameters around the factual determinations that they need to make. But it is not an easy question to grapple with, because any bald heading that you normally have in a threshold document has to be supported by evidence of particular or specific incidents. And what the court says about, okay, we're now in this position where we're going to direct you in a new approach. What do you do? What do you do in the interim before there is a new practice direction, before there is a change in the rules? The court recognised that in most cases, if not all cases of domestic abuse, there is an element of coercive and controlling behaviour. So it is likely that if an issue of controlling and coercive behaviour is raised, it will be the primary question, irrespective of whether or not there are more specific factual allegations to be determined. And what the court is very clear to emphasise is that it's no longer acceptable to regard incidents of coercive control that existed or happened during the currency of a relationship to be irrelevant and to simply be dismissed as in the past, because that very well could establish the basis upon which risk can be, or establish the basis of risk in the future. Of course, as I have already pointed out, the issue with putting controlling and coercive behaviour and establishing a pattern of behaviour at the epicentre of any case or many cases where there are allegations of domestic abuse is going to invariably involve escalating or increasing the scale and length of proceedings. And what the Court of Appeal says about that is that's a difficult question and requires further consideration. It does, as I've set out, give some pointers to practitioners and tribunals dealing with this question as to what they should bear in mind, whether considering whether there should be a fact find, what the remit of that fact find should be. But it's by no means a clear blueprint. It emphasises, again, the underlying principle of Practice 12J, that is, the allegations must be relevant to the determination of the child welfare issues that are before the court. They must be necessary to provide that factual basis upon which that welfare decision, whether it involves an assessment of risk, whether it involves a direction for domestic abuse work, it has to be relevant to that end point of making final arrangements for the care of children all the time that a child spends with one or other of his or her parents. And it is only those allegations that are necessary to support that process of relevance that will be determined. There is a new factor that they propose, and that is in every case where domestic abuse is alleged, both parents should be asked to describe in short terms, either in a written statement or orally at a preliminary hearing, the overall experience of being in a relationship with each other. What's not clear is how that in fact will work, because of course at the moment there is a general prohibition on providing any evidence, birth or hetera, for example. So it may be something, if you're advising a client, to think about. It may be something that you want to include, for example, in your application, in your C100. And this is the final point that they make, is that if there is an assertion of coercive and or controlling behaviour, that should be the primary issue for determination, and it is only those factual allegations that are probative of an alleged pattern of behaviour that should be selected for trial, unless, for example, there is an allegation that is so serious that it justifies determination, for example, an allegation of rape. Of course, I would suggest that that proposal makes perfect sense. However, what it doesn't do is give any assistance to how you select those examples, because of course an example, an incident in of itself is not going to be sufficient to establish a pattern of behaviour. So it may be, particularly if you're looking at a pattern of behaviour over a number of years, that you have a general threshold type allegation. He did or she did X, Y, and Z over a number of years, for example, in such and such a year, and you particularize it in that way. So you may not cite each and every one example, but the most serious example, remembering on each occasion to have in mind the impact that the accumulation of these incidents, the impact that that cumulative pattern of behaviour had on the alleged victim. Finally, the relevance of criminal law concepts. The Court of Appeal actually dedicates quite some time to this, but in fact, the simple answer is that it's fundamentally wrong for a family court to be drawn into an analysis of factual evidence in proceedings relating to the welfare of children based upon criminal law principles and concepts. There is no bar to judges referring to terminology such as rape as a general label for non-consensual penetrative sexual assault. To do otherwise would be wholly artificial. But what the family court must not do is engage in a detailed analysis of the various elements of an offence and whether or not it applies and satisfies a finding in the family court. To finish, therefore, there is no doubt in my mind that the H&N is an extremely important and useful authority, but it's not radical. The President begins his judgment by accepting that the extent of the general guidelines, the guidance is necessarily limited. It's a stopgap, but it may be a stopgap that we are going to be relying on for the next few years until there is a determinative change in either the rules and or by way of a practice direction. I have spoken for far too long and I apologise for that. It is now 12 o'clock. I'm going to have a look. Oh gosh, we've got lots of questions here.
I don't mind starting with a couple on covert recordings, Emma, to give you a chance to have a look, if that would help.
I'm going to stop sharing my screen and I'm going to hand over to Aimee.
I can't believe the number of issues created by covert recordings, even within this group this morning. I can see all sorts of problems, and unfortunately people doing all sorts of things with recordings that they probably ought not to be doing. Anne has asked about the cases with that have highlighted unprofessionalism. I think those are really important cases because we know just how much weight the court places on professionals, and in particular single joint experts, and how hard it can be to persuade the court that there is a flaw in there. And Anne's asking about whether or not clients ought to be covertly recording in the first instance for their own reference. I think a really useful starting place is the Transparency Project document that I've referred to. I'm going to make sure that my link, when it's circulated after this, is to the most up-to-date version on the website. There haven't really been many changes. They fixed some typos. They refer to ReB. But I accept that professionals are uncomfortable with it, would prefer not to be recorded. I'm not sure, given what I've read, that saying I'd really prefer not to is enough. The debate from the Family Justice Council and also the transparency document really encourages openness, and that you should probably be asking first. And if someone is saying no, that you ask for an explanation, because there may be a very good reason why that person wants to record and not a terribly good reason as to why the professional is saying no. The theme of what's said and the content of that debate is professionals ought to be going forward more open and perhaps less afraid of recordings. So I'm not sure that I would necessarily just covertly record as a first port of call. It may be if it's in the case of a local authority or a social worker who doesn't like the idea of being recorded, that's referred perhaps to the solicitor with conduct of the case to ask if there's a particular explanation or reason given. Someone else has asked about whether or not there are cases where negative comments have been recorded to a child, or alienation. The example that Debbie Singleton gave from NIAS in the debate was that call. I think that was a recording potentially of indirect contact, but those comments were made in front of the child, and the court found that they demonstrated how hateful the mother was towards the father. So yes, there are examples, I think, that demonstrate alienation. I've certainly been involved in cases where the recordings have demonstrated that, but the flip side is you've got to be careful that you are not deliberately allowing a situation to unfold which is unhelpful for the child just to evidence gather. Someone has asked about Ring doorbells. I'm not really sure if you need to be upfront about having that. Lots of people have Ring doorbells these days, don't they? For a variety of innocent reasons. I don't want to take up all of the Q&A time. So if I hand over to Emma, and then if I spot another one, and if we've got time, I'm more than happy to take it.
Gosh, we have an enormous amount of questions, and I'm really sorry, I don't think we're going to have time to answer them all. And I apologise for that. I'm sure that Aimee and I are very happy to go through them and perhaps email you all with some short answers if that would help. I've got a message here that I've honed in on because the person has the same name as my sister. And that is, when there are allegations of domestic violence which are disputed, is it best to have a separate fact find hearing or a composite final fact find, or does it depend on the circumstances of the case? I think it depends very much on the circumstances of the case. Again, what do those allegations go to? I think it is difficult because if they are proved, then the question will be whether or not there needs to be some form of risk assessment before any final arrangements can be made. And if, for example, they are not proved, then it may be that if there aren't any issues, for example, of exaggeration or fabrication, that the matter could go, that the court could go forward to determine the arrangements for the children. But I think it very much depends on each individual circumstances. If contact, for example, had been suspended pending a determination of the fact find, it may not be possible to simply make final orders at that stage, because then it may need to be a period of transition, of reintroduction and rebuilding relationships. So I hope, Louise, that answers your question. There is another, there's a comment about might the increase in domestic abuse allegations be associated with the fact that it has to be alleged to access legal aid. I'm afraid to say I think there probably is some basis to that. I think, and it's such a shame that some people feel compelled to make those allegations in order to obtain legal aid. However, what that mustn't do, the fact that some people may abuse the system in that way, I think mustn't stop us as practitioners taking very seriously any allegations of abuse and doing our utmost when before the court to ensure that the court deals with those allegations fairly. But I accept it's very difficult when you have one person's word against the other.
I've got one quick one from Mark about a Children Act case where fathers recorded a call between himself and an anonymous caller who didn't want to give his name and address and didn't know he was being recorded. What are your views on if this should be allowed in? Not knowing the case, with a massive caveat, I don't see a huge difficulty admitting it as evidence. I think that might come down to the weight, though, that the court might attach to that caller, because it might be a little bit like sometimes we see in documents anonymous reports to an authority or to a social worker, and the suspicion from the other parents that it's all been set up by the other parent to cast them in a bad light. So yes, possibly would go in, but just depends how much weight can be attached. And of course, I wonder if there is a question over if you were to provide that that call, if the other party, perhaps mum, might recognize the voice and say, oh gosh, I know who that is. That's so-and-so's best friend saying something really unhelpful about me, and this is all engineered. Maybe I've got an overactive imagination, or I've just become too cynical. I don't know. That's really, that's an interesting one.
I think the other point as well, Amy, I think that's absolutely right, is of course, it may be, if you do want to rely on that as evidence, that you'd have to make a formal application, because the rules require that generally that a witness is identified. And there is a complex body of law that deals with admission of evidence where your witness wishes to remain anonymous. It's different, I think, to somebody making an anonymous referral to the local authority, for example, which would then trigger an investigation and evidence gathering exercise. I think I would be very cautious and want to know from my client how this recording came about, the motivation behind recording this person, Um,
And how did this person get his number as well? It raises, the more you think about it, it raises all sorts of questions, doesn't it? How, you know, for example, it was on a mobile phone. Does an unknown person just ring? Yeah,
yeah, I think it you know, that ultimately, what does it go to? How much weight is the court going to be able to place on that evidence? Aimee, it's now 10:12, and I'm sure that a lot of you have got to get on and have lots of things to do today. Thank you very much for coming and listening to us both on this beautiful sunny morning. We hope that if you've taken away just one or two points that are helpful in your practice, then that is a good thing, and we hope that you then feel it's been worth taking the time to attend this morning. Finally, we are now taking a break from the brunch seminars over the summer holidays. Hooray! And we will be picking up on the monthly cycle in September on the last Thursday in September, which is September the 30th. So look forward to the invitation that will be dropping into your inboxes after the summer. Thank you very much indeed.
thank you.